Accused child killer David was back in court for a very important hearing because we just got confirmation on what is going to happen next in this murder case. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. By the way, if you're putting things out on social media, if you're into content creation, you might be wondering, how do we share all these clips on these rapidly developing stories so quickly? Well, we use something called Opus Clip. Opus Clip is an all-in-one AI editor that makes it a breeze to cut, create, and upload videos across any platform. Through AI, Opus Clip generates B-roll, it reframes footage, and it even cleans up audio. Using Opus Clip is so easy. You just visit opus.pro/sidebar. You sign up, you upload it. In minutes, you'll have perfectly edited clips ready to go. For TikTok, Shorts, Reels, Opus Clip is really your one-stop shop. And having a tool like Opus Clip means that our producers can get you viral courtroom updates instantly. This is the most powerful tool there is to share ideas and edit like a pro. So go to opus.pro/sidebar to get a free week and then 50% off. Okay, July 7th, 2026, we got this brand new hearing that just happened in the David case. I'm going to be bringing on a reporter in a little bit who was in there. We'll give a play-by-play of what happened, how David looked, how he acted, what we can expect next. Two things. First, I'm going to give you context. And two, I got a very interesting update in this case. It just came down. So let's first start here. David. David is the romantic homicide singer, currently charged with first-degree murder, continuous...
D4vd, the singer known for his breakout hits, is charged with first-degree murder, continuous sexual abuse of a child under 14, and unlawful mutilation of human remains. Prosecutors say all three charges connect back to the death of Celeste Rivas Hernandez, a 14-year-old girl he allegedly knew personally. According to the case filed against him, Celeste died in April of 2025, and her body wasn't discovered until 5 months later, in September, found inside a vehicle registered to him at a Los Angeles tow yard. Because of the specific circumstances alleged in this case, including that the killing was allegedly tied to silencing a witness and allegedly involved financial motive, prosecutors have the option to pursue the death penalty. California currently has a moratorium on executions, so even a conviction carrying that sentence wouldn't result in an immediate execution. But make no mistake.
No additional updates on that today, but I can tell you what the status of that is overall in this case. In California, yes, there is a moratorium on executions. Governor Gavin Newsom halted those, I believe, back in 2019. But in this case, because there are special circumstances as part of this first-degree murder charge against David, he actually is eligible for the death penalty. So they could ultimately seek that if he's convicted. And of course, with executions halted, he wouldn't immediately be put to death.
This is legally still classified as a capital case. Since his arrest, this case has gone through two prior status conferences, one in May, one in June, and both times the case got pushed back. Today was supposed to be more of the same.
Hey there, Jesse. I love that you open with that question. I think every time we talk, he didn't look great. I mean, he had longer hair. He was unshaven. He came in wearing his regulation LA County jail uniform, that orange jumpsuit with a white shirt inside. But he was very engaged, totally present, sat down, made eye contact with the judge. And they even exchanged a bit of small talk. He said good morning. He was smiling. And here's the major update. It's not that David isn't looking great, or that his defense attorneys are still stalling for more time as part of their strategy. The significant update today following the status conference is that this case is actually moving forward. This is now our third status conference in this David case that we're chatting about. The last two, as you recall, deja vu, because we've done this now a couple times. They were both continued, meaning the case was essentially delayed during those last two status conferences in May and in June. Well, this time, we all came in expecting this case to be continued, again, to essentially be delayed one more time. But no, they're moving forward. This is actually going to a preliminary hearing now, and that is set to start on Tuesday, July 21st, so 2 weeks from today.
Instead, everything changed. According to reporting from inside the courtroom, D4vd appeared more engaged than in previous appearances. Seated at the defense table, attentive, at times exchanging small talk with the judge. But the real headline isn't how he looked. It's what his attorneys agreed to. For the first time, both the defense and the prosecution appeared to be aligned on one thing: this case is ready to move to the next stage. That next stage is called a preliminary
As
hearing.
soon as I walked in, I noted on defense and prosecution, it felt like they were kind of on the same page. They both understood. I think this case was finally going to move forward. So the judge closed by, chatting with them about how water and coffee would be allowed in the courtroom moving forward. She made a joke about how we're going to be here for the long haul. So again, preliminary hearing starting Tuesday, July 21st. And they've mapped out, dates for the next 2 weeks in case that hearing takes more time. So Tuesday the 21st, Wednesday the 23rd, Thursday the 24th, Friday the 25th, and this could drag on into the following week, especially as they get into evidentiary hearings, because we know there is a lot.
And it's officially scheduled to begin on Tuesday, July 21st. Now, if you're not familiar with how this works, let me break it down quickly, because it matters a lot for what happens next. A preliminary hearing isn't a trial. There's no jury. It's a hearing in front of a judge where prosecutors have to show they have enough evidence to establish probable cause. Basically, enough to justify sending this case to an actual trial. It's considered a relatively low legal bar compared to what prosecutors would need to prove at trial. But it's also the first real opportunity for the defense to see in detail what evidence the prosecution is planning to use
as part of discovery.
Let's take a step back here. So I looked at some of the notes here. They set up to actual times when court would start for all of those days. A preliminary hearing in this case is significant because that is when the prosecution will have the opportunity to present their case. Now, not all of their case. They have to present sufficient evidence to establish probable cause, sufficient evidence that there is probable cause David committed or allegedly committed these crimes to convince the court there is enough to go forward with an actual trial. Now, this is in front of the judge. This is in front of the court. There's no jury here. It's a low standard, right? It's a low bar. By all accounts, the prosecution, from what we've seen, will have sufficient evidence for this case to move forward, but it does give the opportunity for the defense to challenge the evidence, to see what the prosecution has, kind of a preview of where they may go with the trial. But I want to just take a step back here before we even talk about next steps.
To start pushing back on it in open court, because there's reportedly a large volume of evidence in this case, including significant digital data that was handed over during discovery. The court has already blocked out multiple days to make sure the hearing doesn't get cut short. We're talking about proceedings potentially running from July 21st through the following Friday and possibly spilling into the week after that if things take longer than expected. One detail worth noting, prosecutors have reportedly confirmed that all evidence considered relevant to this specific hearing.
That evidence, the voluminous evidence in this case, the defense is ultimately going to challenge. Now, the defense attorney did say that, according to the DA in this case, they have all the evidence that is relevant to the preliminary hearings that they were supposed to receive as a part of discovery when they're sharing evidence between the two sides. They did say they requested chronologies from detectives. They're still working on getting that. But again, it is significant that every piece of evidence deemed
has now
relevant
been turned over to the defense. That's a significant marker because it suggests the defense finally has what it needs to prepare its strategy heading into these hearings, which may explain why both sides seemed ready to stop delaying and get moving. There were a few other developments during today's proceeding that are worth flagging.
Yeah, that was interesting. This conversation started actually months ago, and there was a lot of back and forth. There was a lot of debate between defense and prosecution about how to protect parties involved in this ongoing case. So apparently, prosecution sent back a revised draft of what they thought would be an acceptable protective order back in May. And they haven't been able to agree upon anything until today. So defense attorneys came back and said, they've reached a conclusion about what they felt like they needed. That was submitted to the court today. And it sounds like the judge signed off on those protective orders at the end of the hearing. That bit might have actually been off the record. That was not something they shared in open court with most media present. But they did state that they've agreed upon what they need in protective orders. They did not say who it covers, but we can guess there might be people on the witness list who are covered by those protective orders.
And particularly in a case this high profile, where you already have a question about jury selection, it's not surprising that you see these orders being
First, a protective order was finalized. Prosecutors and defense attorneys had reportedly been negotiating the terms of this order for months, going back and forth since at least May. The purpose of a protective order in a case like this is typically to shield certain individuals, often witnesses, from having their identities or information become public before trial. The specifics of who exactly is covered under this order weren't disclosed in open court, but given the sensitivity of this case, it's reasonable to assume it applies to people expected to testify. Second, there was discussion about grand jury transcripts. This case was not brought through a grand jury indictment. It moved forward through the traditional preliminary hearing process instead. However, it's been reported that a grand jury was convened at some point during the investigation, and the defense is now seeking access to whatever transcripts exist from that process. The court indicated that request will be—
That's interesting, because that's part of a larger conversation we've had in this case, right? This was not an indictment through a grand jury. This is trying to move forward through a preliminary hearing, right? There's two ways for this case to progress. And our understanding is there has been several grand juries that have been impaneled this case, maybe to evaluate evidence, but we don't know if whether or not these were grand juries that had the power to indict or not, but there has been no grand jury indictment, right? There's been no official charging of him through a grand jury, but it seems the defense is interested in transcripts of what happened at these proceedings.
That should be something shared during the discovery process. And you're right, Jesse. I think there have been way more questions than answers when it comes to that piece of this murder investigation. There was no grand jury indictment, and we really don't know what went down as a part of that process. So they had questions just about the logistics of how they were going to get those transcripts. That sounds like, are they getting recordings? Are they getting a stack of papers with printed transcripts? Are they getting a digital file download? And the prosecution and judge responded that they would actually go through the grand jury for that. But once defense attorneys get their hands on that data, however it may be coming through, you can bet bits and pieces of that relevant to their case, relevant to their
routed
defense.
Through the grand jury directly. This is worth watching because defense attorneys frequently use grand jury records to argue that prosecutors withheld favorable evidence or misrepresented facts. And if that argument gains traction here, it could become a real flashpoint later in the case. Third, there was conversation about a defense investigator and where that person would be seated.
Did that come out today? The defense maybe has a defense investigator?
That did come out, and there was a question about where that defense investigator can actually sit. It sounds like they've got two chairs at the defense counsel table in front of the judge. Obviously, there's one chair for David. He was seated right on the end of the table today. I was basically catty corner facing the front of the court on his right-hand side. So I had a clear view of him in profile looking at the judge. But yeah, the defense investigator might be seated right next to David or his lead defense attorney. So yes.
During proceedings, a small logistical detail, but one that confirms the defense team is actively building a competing narrative to challenge the prosecution's version of events.
So we have not seen any kind of witness list just yet. I know, Jesse, you and I have chatted about that a couple times, wondering who might ultimately be called to the stand in this case. I know there were questions, a lot of chatter online about members of David's family who might ultimately be called to testify. So we didn't see a witness list. There was chatter this morning during this hearing, however, about exactly where those witnesses might be seated at the counsel table, the benches of lawyers in front of the judge in this courtroom. So there was some back and forth just clarifying, how many people can be seated at that table? Where exactly are they going to sit? It sounds like defense attorneys want to make sure, they have enough contacts to make sure their witnesses are comfortable testifying. Of course, they're all coming in. I don't want to say coached, but prepared. They're all coming in understanding just how high the stakes are here, what David could be facing. Because again, he's not charged with only murder. it's murder and 2 additional felonies on top of that, mutilation of a corpse and continuous sexual abuse of a child. I haven't seen anything.
Okay.
I've heard a lot of things. I think we all have. What I have questions about here is not so much this rumored rift between the LA County Medical Examiner's Office and the LAPD. I'm curious about the LAPD, the City Police Department, not being on the same page as the LA County District Attorney's Office. We've talked about this before, how days went by between the arrest of the defendant here and actual charges being filed. So different agencies, different roles. And yes, there are questions about these different agencies not really being on the same page. This is interesting too. You know, these are investigative bodies. But I want to point out what the defense, what reps for David's team said very early on when they said he was cooperating with LAPD. That was another example of parties not really being on the same page and messaging not really being aligned. Because an LAPD captain came out later on and said, no, you know, we didn't authorize that statement. We didn't have awareness of it. And come to find out, this is the man now charged in this case. I don't believe he was cooperating with them at any point in the way that his team may have said. So a lot of different parties, a lot of different motivations. And I think in this courtroom, we'll see how all of this shakes out. Who's got the strongest case?